Please be seated. Court now calls case number CV130199, Alpert versus Bivens. This is the time set for oral argument. Counsel, a couple of preliminary matters. These proceedings are being audio and video recorded. You may have even been in the courtroom when I gave this advisement earlier, but this the proceeding does have a link to our court website, and it will be on the court website within a couple of days. Please identify yourself and your client when you step up to the podium. You have 20 minutes. Appellant can reserve some rebuttal time if you wish to do so. As you are probably well aware, we've read the briefs, we've conferenced the case, so we're familiar with the issues. And you can keep track of the time by looking at the clock on the podium. Counsel?
Randy Johnson and Mark Sampson, Your Honor, for appellants. I will be conducting the argument today. May it please the court. All of Appley's argument in this appeal are fundamentally flawed by the same misconception with regard to the application of the case within a case doctrine. All of them essentially analyze the case with the underlying case still burdened by the negligence of Appley's and the fruits of that negligence. They ignore the case within a case doctrine as mandated by the laws of every reported decision of this state. As the court is well aware, this is a legal malpractice case involving an underlying litigation case, and the laws of virtually every state in the union mandate a case within the case analysis under those facts. If I had but 90 seconds to make an oral argument in this appeal, a hypothesis I fear would satisfy my opening prayer, that it would in fact please the court. I will say that number one, I would make three observations. Number one, with regard to appellant's claim that the underlying case was barred by limitations because the claim accrued upon the calling of the letters of credit, I would direct the court to a statute not cited in our brief, the Uniform Commercial Code 5.108. That statute expressly rebuts the implication that somehow a letter of credit is irrevocable and automatic and instantaneous in connection with the accrual of damages. With regard to the alternative claim not addressed by the court below that somehow appellees were impotent or incapable of curing the real party and interest flaw in the case, thereby excusing their failure to discover it and attempt to cure it, I would simply say that the first firm's due diligence, honest mistake, good faith, difficulty in determining the proper plaintiff, all the issues mandated under Rule 17 compost into a loss of that right under Rule 17 with the passage of time, and as a result of the negligence of defendants become indifference and conscious disregard of the issue. And with regard to the issue granted by the court below, what is characterized as an extinguishment by assignment, which for shorthand I will call the assignment defense, I would say it mandates that a court completely ignore the case within a case requirement imposed by the laws of this state. When the case within a case analysis is applied to the underlying case, and the negligence of appellees is removed from the case, the real party and interest case problem thereby being cured, the 2007 assignment, which appellees in their motion concede was drafted to address and cure that problem, disappears. Or at a minimum, there's a fact issue as to whether it would have been in existence had that problem been cured. I'll concentrate my time on the assignment defense unless the court has questions about the two alternative grounds originally filed in the motion for summary judgment. And I concede to this court some form of first blush eyewash appeal to the claim that the 2007 assignment divorced the damage claim from the malpractice claim. That argument fails for three reasons. Number one, it perverts the case within a case requirement by analyzing the case still burdened by the fruits of the original negligence of the lawyers. Under the case within a case analysis, when the lawyer's negligence is removed and the real party and interest problem is cured, there is no reason for the 2007 assignment. BNN describes this as a rewriting of history, and yet not one reported case in this state characterizes a case within the case analysis as a rewriting of history.
So you're asking us to hypothesize that the 2007 assignment would never have occurred?
No, Your Honor. If I may be so bold, as the recipient of the motion for summary judgment, I would say I don't have a care one way or the other what you hypothesize, because it was their burden to establish that it would have still been there. If they're going to apply the case within a case analysis and say it's barred by the 2007 assignment, they must prove that even when their negligence is removed, that 2007 assignment would have still been in the case. And there is no summary judgment evidence to establish that. And in fact, logic, I would submit, dictates the contrary.
Okay.
BNN calls, however, the hypothesis of what would have happened something that this court must address, or at least rather the trial court must address under the case within the case analysis, an impermissible alternative history. A quote which somewhat conveniently led me to the Sutter decision cited in our brief, out of the highest appellate court in the state of Maryland, where the defendant made the exact same argument. There it was the client fighting against the case within a case analysis and called it an improper rewrite of history, to which the Superior Appellate Court of Maryland, which is the equivalent of their Supreme Court for civil matters, said that the argument does not comport with the purposes of the case within a case doctrine, which is to determine what would have happened had the lawyers not been negligent in the first place. An issue, the court said, is a question of fact, which obviously precludes summary judgment. Under the case within a case analysis, BNN's proper handling of the real party problem in 2006, at a minimum, creates a fact issue they failed to rebut with regard to whether the 2007 assignment would have even existed, and that precludes summary judgment. The second reason that logic is simply turned on its head with this argument. I ask myself, what could appellants have done to preserve their right to sue the lawyers for not discovering and curing the mistake, or at a minimum, if they couldn't cure it, not telling the client so that they can abandon the lawsuit and save hundreds of thousands of dollars in legal fees? In the posture the case comes to this court, the negligence of the lawyers is presumed because we are the recipients of the summary judgment motion. So, option one, assign the case to JV to try to cure the real party and interest problem. We know that cure didn't work. Florida court said, wrong plaintiff, you lose. Appellees say, well, now you have divorced your damage claim from your malpractice claim. Sounds right. The reality is, in every legal malpractice case involving underlying litigation malpractice, the malpractice claim is divorced from the underlying claim. They are two entirely separate proceedings where, in fact, the clients are allowed to take entirely inconsistent positions. Arguing, for example, in the underlying case where those at issues, my lawyer timely disclosed the expert witness, or in the alternative, for some reason, should be excused from doing so. And when that issue and the case is lost, in a divorced proceeding, malpractice claims are filed and the lawyer gets to claim the exact opposite. Lawyer, you were negligent because you didn't disclose the expert witness on time. Option two would be, don't assign the case. Don't even try to cure the real party and interest problem and save the lawyers from the consequences of their negligence. Result at trial, you lose, wrong plaintiff. Exact same position, but is Danro then allowed to sue? Can they somehow file a lawsuit against their lawyers for negligence when they don't even try to save the lawyers, while they can't sue when they do try to save the lawyers? It simply makes no sense. I hypothesize, for example, of a bank that is in receipt of hundreds of consumer notes polluted with the negligence of a lawyer that includes a pregnant usury counterclaim. Must the bank sue every one of those clients and be hit with the counterclaims in order to sue the lawyer? Does the bank lose its right to sue the lawyers for all its losses if it assigns those claims to someone else and lets them go sue and incur the counterclaim? The bank could sue under every one of them.
They're two very different questions, perhaps with two different
They are.
answers.
I agree they are, Your Honor. But the bank could sue the lawyers for polluting the notes under every one of those. And if the bank could sue, why can't appellants in this case?
Counsel, was the decision of the Florida court appealed on these very same issues?
No, the Florida court did not address the issue of whether the malpractice case was divorced from the underlying case. It addressed only the underlying case.
And it addressed only the limitations issue.
The 11th Circuit addressed only the limitations issue. The trial court addressed both limitations and real party and interest. That's correct, Your Honor.
Did the issue of real party and interest get appealed in the Florida decision?
It did, and the appellate court found it unnecessary to reach it because it ruled the case was barred by limitations
I
regardless.
remember reading that.
So how can the law punish appellants by saying you cannot sue your lawyers when you are forced by the lawyers to a decision of either helping the lawyers by trying to eliminate their malpractice with the 07 assignment, or in the alternative, ignore it? How can the law countenance that decision?
Well, let's go back to your bank hypothetical.
All right?
You suggested two scenarios. Number one, the bank chooses not to enforce its notes, but instead sues the lawyer because of the unenforceability of the notes.
Correct.
I don't see a problem with that lawsuit against the lawyer. Do you?
No.
Okay. Situation number two, the bank assigns away the notes, and the assignee now finds itself with a bunch of bad notes and no malpractice claim because it wasn't the client, right?
I'm sorry, the assignee finds itself with bad notes and?
No malpractice claim against the lawyer.
The assignee has no malpractice claim, but the bank still does. The bank, the actual client, had a valuable asset, gave up a lot of money in loans, and got nothing for them because of the lawyer's malpractice. And here our issue is not.
So in your hypothetical, then, the bank's assignment of the notes is basically just mitigation of damage.
Exactly, Your Honor.
It retains its claim.
Exactly.
Okay. I'm not sure that I see that. I mean, I'm following your reasoning in both hypotheticals. I'm not seeing the connection, though, to this case.
May I attempt to provide that? In 2007, the case is 2 years old, months away from trial, being prosecuted in the name of the wrong plaintiff, a plaintiff picked by the lawyers at firm number one without all of the documentation. We're now at a point where correcting that under the specific procedural rule for correcting it, Rule 17, has long since passed. Denro, one of three related entities who had jointly pursued this claim, as alleged in the pleadings, looks at a situation where I'm the real party in interest, and I'm not a party to that. And the only way this claim can be preserved is if I get to join. But under Rule 17, I can't join. So I'm going to try to preserve the claim by giving it to James Venture at this late date, which we know failed.
Right, but here the malpractice claim isn't for the diminution in value that it experienced by virtue of making the assignment. The malpractice claim is for losing the case.
The damages are the exact same, Your Honor.
What
did Denro get for the assignment? Nothing. What did Denro get from the lawsuit? Nothing. And the act of assigning.
This wasn't an arm's length transaction either.
No, of course not. As we have alleged, and as they should have alleged, all three of these parties had been involved in the joint pursuit of this for some time. The damages being sought were damages incurred by all three of the appellants in this case, each one of them having contributed a different role in the prosecution of the claim against Timco.
I don't want to spend too much of your time on your analogy, but isn't there a difference between saying that the lawyer gave me a bad asset and the lawyer lost a case? Because the case within a case doctrine doesn't apply neatly to a bad asset the way it does.
I agree with that.
A poorly handled piece of litigation.
No, I agree.
Okay.
The bad asset is, in fact, a transactional malpractice claim as opposed to litigation. I agree with the court on that point.
Okay.
But that does bring me conveniently to my third reason that this argument fails, which is it is simply horrible public policy. It effectively allows the lawyers to have eliminated their own liability at the expense of the client. And There is no place in the law of any state I know of which regulates strictly lawyer relationships with client that would permit the lawyers to extinguish their liability in this fashion. To the extent that...
But these defendants, this defendant, this firm at issue in this case, didn't do that, did it? That was the successor firm who settled out.
But no distinction is made by appellees, and that's not the settlement, by the way. It's wrong to talk about settlement. That is true. The first and third firms have settled out. But if firm number 3 can wipe out firm number 2's liability, so can firm number 2 by doing the same thing. There's no difference in who recommended or was sitting at the helm when the assignment was made. Appellees do not make that distinction.
I see a huge difference.
Tell me the difference, Your Honor.
The difference between allowing a defendant to eliminate its own liability and allowing another law firm to eliminate liability for the defendant seems
No, I understand that.
clear.
Under the theory of appellants, of appellees, the 2007 assignment eliminated the personal liability of the 2 lawyers who were liable at all 3 firms. It wiped out all liability.
But
The
you don't have-
personal lawyers are relieved of liability, not just the firms.
Hang on.
Yes, sir.
The Bevins and Noor firm existed from January of 06 to June of 06.
July of 06, correct.
Late June of 06, however you want to call it.
Right.
But it seems to me like you're trying to reach into the precedent acts and bring those into the area of obligation of Bevins and Noor, and you're trying to go to the subsequent acts and bring them backwards into Bevins and Noor and say that Bevins and Noor should be responsible for the 2003 transfer, the 2005 contract, and the 2007 assignment.
That's not true. If that's the impression I've given, I'm wrong.
That's the way the pleadings seem to read it. It just kind of merges it all together. Tell us where the distinction is.
Law firm number 1 filed the case and put 2 flaws into the case. They picked the wrong party plaintiff. Mr. Bivens' deposition makes it clear it was his duty and he picked the plaintiff. The testimony is he did not have all the documents and he had to file in a hurry. While we believe there's error there, we believe that it is somewhat excusable by the exigent circumstances under which he found himself. January 1, Bivens and Noor takes over and has the opportunity to cure both of those flaws and fails to do so. For 6 months, fails to request documents, discover the issue, fails to avail itself of a 4-year statute of limitations. The case then goes to the third law firm, which continues to prosecute the case. The acts of that firm are essentially irrelevant at this point in time.
But they still had the ability at that point to do anything Bevins and Noor could have done.
If they do, then, Your Honor, that raises a fact issue of comparative fault at best, which does not relieve Bivens and Noor of its liability, and summary judgment would be improper.
Go ahead.
May I conclude where I began simply by saying the limitations defense is fully rebutted by Uniform Commercial Code 5.18. The real party impotence on real party is rebutted by the fact that the case Bivens and Noor inherited, they had the perfect opportunity to assert all of the requirements under Rule 17. That composted into an abandonment of the rights under Rule 17 with the passage of time due to their neglect and purposeful refusal to pursue the real party. And the assignment defense is rebutted by its refusal to acknowledge the case within a case doctrine. Perhaps counsel in this appeal will answer the question it never answered in its brief, which is, how does the 2007 assignment even arrive if Bivens and Noor corrects the real party and interest defense in 2006 as it should have? We respectfully request the court reverse the judgment of the trial court below and remand. Thank you, Your Honor.
Counsel?
Great. You need this space? Sure, you can have it. I don't need that space.
I'll leave it there. Thank you.
Good morning. May it please the court. I'm Andrew Peterson representing Bevins and Noor. After the hearing on our motion for summary judgment, appellants quickly filed a motion to amend. They know that they lose this case as a matter of law. Their new argument was this was some kind of a joint venture, and we haven't heard any argument today about that, denying that motion to amend, but that's what they tried to do. They know the case is barred as a matter of law. And Judge Cooper, when she looked at their motion to amend, decided it for the same reasons, that it's futile. At this point in time, it's futile to make that argument. It's futile because it directly contradicts the 2007 assignment. Although also not decided by Judge Cooper, they've never argued, and this is one of the problems with this case from the beginning. They've never made a distinction about who has the claim and for what. They just lump everybody together, the three entities, Dan Rowe, James Venture, and Mr. Alpert, and they never separate them. And this is the same problem that they got into in Florida, where the district court said they're playing a shell game. The same kind of problem.
Well, why did the 2007 assignment happen?
Because there was concerns about who had standing, who was the real party in interest, and it had actually been raised quite some time before then. I think the attorneys felt that it was rather ambiguous. They didn't know what to do about that initial 2003 assignment, and so they did the 2007 assignments to clear things up. But as you pointed out, that was not BNN. The 2007 assignment was not Bevins and Norrie. That was done by Florida Council.
Not by Snell and Wilmer?
Well, they had some input. The input was Paul Stoller, and we cited that in our brief, at Snell Wilmer making a recommendation about cleaning up the assignments. And he actually gave the recommendation wasn't followed as to what he told them to do. Yes, Your Honor.
You heard my question, counsel. I mean, you've got a 6-month window when Bevins and Norrie even existed. It seems to me like everything that occurred before is getting pulled into that 6-month window, and everything that happened after is getting pulled into that 6-month window. Even if there was the potential for remedy after June of 06, or whatever's going to take place, whatever's outside that window, it falls to these two folks to have fixed it.
Well, that's what they're trying to put it all on us now.
Well, I understand that. Is there a basis at law for doing that? Is there
No.
a basis at law for saying that anything that passed through that window somehow should have been radiated out of the case?
No, there is not. And it's important, for instance, they claim that during that time frame, we could have cured it under Rule 15 or Rule 17, right? They don't cite the applicable law. This is in Florida. They don't fight. This is in Florida District Court. The Florida District Court, in its decision, pages 6 and 7 of its decisions, it's real important. It talks about this while they're trying to cure it at this point in time under Rule 17. In the cases it cites, in the Florida cases it cites, it talks about how this is a standing issue and a real party in interest. There's a distinction there. Because what the court says is that it doesn't matter. You're too late because James Ventures did not have standing when it filed the lawsuit. It can't use Rule 17. Look at the cases it cites. Live Entertainment versus Digix, Lands versus Gateway, United States versus CMA, the Ninth Circuit case. The cases that they cite say you cannot make your motion under Rule 17 or under Rule 15, and that's the Jaffrey case that we cited. You can't make that motion unless you had standing in the first place. James Ventures never had standing. The idea that this was some magical cure invented later to have saved this case is plain wrong. And it contradicts the Florida District Courts and the reasons why the Florida District Court ruled the way it did. So there's no magical Rule 15, Rule 17 cure during that small time frame because James Ventures didn't have standing. And if they didn't have standing, if you could have added Dan Rowe at that point in time, they don't get the Rule 15, Rule 17. They don't get to relate back. They don't get the earlier filing date. But under Arizona law or under Florida law, this lawsuit was barred before it was even filed under the statute of limitations. And actually, because of that, you don't even have to get to the Rule 15 and 17 analysis. And I want to make sure They show up here today and say, well, we have some new law, the UCC applies. That's not briefed. That hasn't been argued before. What was actually litigated in Florida was when this cause of action accrued. It was never argued at any time throughout the Florida litigation that there was a new accrual date of October 24th, 2001, based on some bank statement produced, in this case, years later. It was stipulated that in the joint pretrial, a stipulation which would not need any proof at trial, under that October and 17th and 18th are when the letter of credits were drawn. That's the date they're using. The court, when it looked at the statute of limitations, also not only noted that, it noted Alpert's testimony, that when these letters of credit were called, he was damaged. It noted Sanders' testimony as to the same. It noted that their expert calculated damages starting from October 21st. All of this is outside the statute of limitations for Florida. So even if there was somehow some way to relate this back to the original filing, they still lose. They still lose under the analysis of the Florida District Court on when the cause of action accrued, what the stipulations were as to when the letters of credit were called and drawn. In fact, when we got into this and went back, they actually claimed losses from this so-called indemnity agreement months before that. They claimed they were not getting their interest. They claimed they were not getting their monthly credit support fees. They were claiming they were sustaining losses and actually had gone to TIMCO trying to get them to replace the letters of credit with something else, and TIMCO didn't do it, or agreed to indemnify them. TIMCO didn't do it, refused to do it.
So you're saying the first event that would have established liability began
even before the stipulated facts as to when these events actually started and when their damage occurred, even before the October 21st date, the October 17th date, the October 18th date. But on any of those dates, they're still outside the 4-year statute of limitations.
Well, if you're going to make the case that the underlying case was just a dead-bang loser before it was even filed, what do you do with the argument then that it was really counsel's duty to inform its client of that fact and not collect fees for years pursuing?
Because what they were trying to do is exactly what was set forth in the complaint. What they were trying to do is to make the argument that their cause of action didn't accrue until the sale of the Killstrom building. That's what they were trying to do. And under that scenario, it was timely in Arizona, it was timely in Florida, it was timely everywhere. That's what they were trying to pursue. Florida court saw it differently. Florida court saw, we think your cause of action accrued much earlier than that. And based on the stipulations, it did. And their losses did accrue earlier than that. And they can't go back and undo any of that. They can't change those stipulations. They can't change Mr. Alpert's testimony. They can't change Mr. Sanders' testimony as to when they were damaged. And they were damaged when the letters were called or drawn. Whatever you want to call it. They were damaged at that point in time, which is outside the 4-year statute of limitations. Let me talk briefly about the assignment. They cannot ignore the fact that the assignment was done, and it was done not by us.
2003, 2007.
2007. Well, neither one was done by us. But focusing on the 2007 assignment, that was done. You know, at no time have they challenged the scope of the 2007 assignment. They haven't challenged any language in the 2007 assignment. I mean, it's absolute, unconditional, irrevocable. The language in that assignment is broad. It covers everything. Any claim that Danro may have had, any ancillary rights to that, everything is assigned away. They have never claimed or pointed out reasons why they should be relieved from the effects of the assignments. There is no carve-out. There is nothing in that assignment that would then allow Danro to now stand up and say, I still have my malpractice claim. I can still claim damages, even though I've assigned everything away. And we pointed out cases to the court and to the appellants on this, which they just chose to ignore. Your note hypothetical was good because there's a case in Florida where this case was pending on the same point, the David Stern case. The fact is that the assignment has real effects. They cannot ignore it. They cannot ignore the law on assignments. They want to try to find a way around the law of assignments. And they tried to do that when they filed their motion to amend after the oral argument on summary judgment. They're looking for some reason to come around the law of assignments, and they cannot do it. There is no reason for this court to go out and create a new law in that area. You know, I was thinking about some of the Arizona cases we cited on the assignments. The Botma case, you know, it's not unusual where an insured gives an assignment to the plaintiff in exchange for a covenant not to execute. You know, in Botma, what happened is the attorneys, the person who got the assignment then claimed, well, the underlying defense attorney had also malpracticed. I want to pursue that claim. Of course, said, no, you can't do that. And then they say, well, we'll pursue it in the name of the insured, the original attorney's client. And the court said, no, you can't do that. And they said at the last paragraph, to allow the lawsuit, which was born out of that assignment, to proceed in Botma's name would be to wink at the rule against assignment of legal malpractice claims. And that's what they're asking you to do. We also cited the Quiroga versus Allstate case, which is another good case. Talks about assignments, the effect of an assignment. There, the insured assigns everything away to get the covenant not to execute, then tries to claim, but wait, I still have a punitive damage claim. I still have a claim that I can pursue against the insurance carrier. The court said, no, you don't. And quoting that decision, by choosing to assign their right to sue in exchange for being relieved from liability, the Quirogas also chose to forego any claim that they might have had for punitive damages. So you can't split them. That assignment's done, it's gone. They didn't even try to do a carve-out or anything here, and they have not challenged that as the 2007 assignment in this litigation. They want us to hypothesize, going back to some of their points, they want us to hypothesize the malpractice, and then we wouldn't need to do the assignment. Well, the fact is that the assignment was done. They can't undo that assignment. Even if they claim that BNN malpractice, they cannot undo the fact that that assignment was done. They say that we pervert the case within the case doctrine. Absolutely not. You have to look at this case, especially under the Rule 15 and 17 analysis, as if it was pending in Florida. And what would have happened in Florida? What were the rules of procedure that applied in Florida? What would have happened there? Under Rule 15 and 17, as noted by the court, this James Ventures did not have standing initially and wasn't going to be allowed to amend. They also noted, and to be fair, they also said, I think this court did both, says you don't have standing, and it makes clear that James Ventures didn't have standing, but it also said, and there's no evidence of an honest mistake. It wasn't hard to figure out. The proper party should have sued initially. And that act, the initial lawsuit, was not BNN. That was the first law firm, not us. You have any questions?
No. Thank you, counsel.
Thank you.
Counsel?
May it please the court, may I be clear on what we're not suing appellees for here? We're not suing them for the initial mistakes in the case. That happened on the first firm. We're not suing them because of the 2007 assignment, which they say extinguished their liability. That happened at the third firm. We're suing them for two events: failure to cure the real party in interest and failure to secure a 4-year statute of limitations. Those are the only accusations against them. They may or may not share liability with other firms for not curing, that being the third firm, but that's a comparative issue and does not relieve them of liability.
How could they have cured the real party in interest problem in 2006?
I think it's an error of innocence, but counsel misspoke when he told this court that the cases they cite preclude curing that problem under Rule 17. The cases he's referring to about lack of standing refer only to Rule 15. Rule 17 is designed specifically to cure the designation of a wrong plaintiff. It states, the court may not dismiss for failure to prosecute in the name of the real party in interest until after objection a reasonable time has been allowed for the substitution. There's case law additions to that, which they say, look here, the court said you didn't have an honest mistake in 2008. That continues to burden the case with their negligence.
That can be done, counsel, by a party that has assigned away its right to
It
sue
cannot
in the
be
first
done
place?
by Danro. It could be done by James. It could be done by the lawyers for these three plaintiffs. It must be done by those lawyers. Rule 17 contemplates you named the wrong party. That's what it starts with. Every case must be prosecuted in the name of the real party. Lawyers, if you screw up, you get to correct that under Rule 17. And they have a huge burden, which they have not met, to try to prove on summary judgment they could not have established the requirements of Rule 17.
But their client was JV. That's who they represented. Why would the lawyers go out and act for some party that they didn't represent to bring them in as a real party in interest? Their party had no standing. They'd assigned away their right. Why would they go out and find some other party they don't represent and file and bring them in as a real party in interest?
Your Honor, under the posture this case comes to this court, our allegations are taken as true that the lawyers in all three firms represented the interests being pursued against Temco. It was Mr. Albert who came to them, and it was the lawyer who selected James Ventures, who chose not to select Danro. And now your question suggests the lawyer can pick the wrong party and then never be sued for it because he didn't represent the right party who was sitting in his office.
The engagement letter says, represent you in connection with the claims of James Ventures, LP, against Timco.
But the testimony of Mr. Bivens in the summary judgment record is, I came in and he picked the plaintiff, and if he had wanted to pick Danro, it was available. This is a family corporation of related businesses. James Ventures is a limited partner. Its general partner is Danro.
They're three separate entities.
Yes, they are. And the lawyer could have sued under all three, saying it's a joint venture of all three, or the lawyer could have picked, as he did, the wrong plaintiff. The flaw of Appellee's here is that they ignored for 6 months documents that showed it was the wrong plaintiff. And the only issue for this court is, have they met their burden under those facts to say they are excused for never looking at the documents and never finding the problem because they could not have substituted under Rule 17. And I'm suggesting to this court that's a burden they cannot meet. They could have done that. Rule 17 is designed for that exact situation. My time is long over. Thank you for your tolerance.
All right. Thank you, counsel. Counsel will take this matter under advisement and will issue a decision in due course. Court's in recess.
Thank you, Your Honor.